Hi, I'm May Shampolsky. I'm a criminal lawyer. I defend those accused of crime. Now, as you well know, there's a couple of ways that people can be charged with a crime. One is by a complaint, the other is by an indictment. When there's a complaint, the DA alleges that something has happened. And then after that, if it's a felony or a gross misdemeanor, then it proceeds to preliminary hearing. Preliminary hearing is a probable cause hearing in which the standard to be bound over, which is a term of art for trial, is slight or marginal evidence. And case law has said it is a scintilla of evidence, which isn't much. And then the other way to be charged is with an indictment, which means the evidence is presented to a grand jury. It's the prosecutor and the witnesses. There is no defense lawyer. And there's an old saying that a good prosecutor can indict a ham sandwich. So what this means is that it's easy for a prosecutor to indict because there's no defense lawyer. And once again, the standard is very low, which is slight or marginal evidence. So that's what happens. That's in state court. In federal court, although it'll be set for preliminary hearing, it never goes to preliminary hearing. They always indict, or if you can agree, you can proceed by information. So that's what happens in federal court. By the way, if anyone has any questions, just ask. I'm happy to answer them. So that's that. Now, federal court is a lot more formal than state court. And if it says it's at 9 o'clock, you better be there at 9 o'clock or you're going to get sanctioned. Ask me how I know. So that's whereas state court, you have what's called a stacked calendar. You're going to have like 30, 40 cases. So you can get there at 9, you get there at 9:15, get there at 9:30. It doesn't matter. Now, in federal court, usually there's many co-defendants. Like I have a couple of drug cases, there's 5 defendants, and many people can't afford retained counsel in federal court because it's complicated and it'd be very expensive. So there's the federal public defender, and then people who are on the what's called the CJA panel, the Criminal Justice Act. And that's lawyers that are qualified, like myself, to handle the case on an appointed basis. The good news is the feds pay $155. The bad news is they are so persnickety with their bills, it's out of control. Whereas in the state, I'm on what's called the murder panel because I take murder cases. That only pays $100 an hour, but it's not a problem getting paid. I just picked up a couple of new murder cases. One, it was actually in the news today. Client's name is Christopher Martell, and he was accused of killing 2 people and attempting to kill 2 other people. I hardly have any discovery, so I don't know all the ins and the outs, but in any criminal case, you have the right to go to a preliminary hearing within 15 days. Now, most people waive it unless they're in custody. First-degree murder, most people are in custody. So he invoked his right to have a preliminary hearing within 15 days. So we're going to go on October 12th. Now, in addition to this, there's a right to speedy trial. Once you get to district court, in state court, you have a right to go to trial within 60 days. Now, it's difficult to prepare for a murder case depending on how much discovery there is, but obviously sometimes the client wants to do it. It's his decision or her decision, and that's what we do. In federal court, there's a right to speedy trial too, but that's 70 days. And sometimes in federal court, it's almost impossible because for instance, I have a drug case right now and there's over 2,000 pages of discovery. How could I possibly get ready in 70 days? But luckily, that defendant's out of custody, so he doesn't care that we go to trial within 70 days. So that's basically the difference between state court and federal court. Now, on I just had a murder case which pled. It was, for better for worse, a gay love triangle. And there was my client, the co-defendant, that allegedly suffocated the quote-unquote sugar daddy with a pillow. And supposedly he liked rough sex. They tied him up. But in the end, my client pled. They wanted 20 to 50. That wasn't working. They gave him two choices. He could plead to second-degree murder, which is 10 to life, with right to argue, which means parole eligibility is after 10 years. You can't get out on parole until the 10 years has passed. Now, most people don't get out on the first time, but usually on the second or third time, unless they're causing problems when they're in prison, they'll get out. The other offer on the table was 15 to 45 stipulated, so there'd be no ambiguity. We know 15 on the bottom and only 45 on the top. Now, what happens in criminal cases on Category A felony, Category B felony, like murder or robbery, is after you get to your parole eligibility, you get what's called good time. And good time is 2 for 1. So if you're supposed to be there 10 years, you'll serve 5 years if you don't make parole. So on my client's case, he'd do the 15 years, and then he'd have 30 left for the 45, but the most he's going to spend is another 15 years, and he's 23 years old. So that's that. I also have another murder case in which my client invoked his right to a preliminary hearing in 15 days. But what happens, sometimes the prosecutor doesn't want to go through the preliminary hearing because as a defense lawyer, I have a right to cross-examine. So what they'll do is they'll indict, once again, go to the grand jury, 18 to 23 people, no defense lawyer, and they indicted my client. In addition to the murder charge, they charged him with tampering with a witness because he called his girlfriend of 2 days, who was a witness against him, and apparently tried to dissuade her from testifying. I haven't heard the tape yet. I'm still waiting for the grand jury transcript, which is another problem when you're going to go to trial in 60 days. So that's what happens. I do a lot of murder cases. I like murder cases because murder is a conceptually easy crime. Unlawful killing of one human being of another with malice aforethought. So that's what it is for murder. And you know, there's a few defenses. The defense that I like is the Sodi defense. Some other dude did it. But the better defense is the Toady defense. This other dude did it. Now I have this other murder case where my client allegedly killed this one person by shooting him, and there's cell records that show his cell phone was in the vicinity of the murder when it took place. Doesn't sound very good, but the gun that was shown to be the killing weapon by ballistics was not my client's gun. There was another defendant, and the DA and I basically played chicken. I said, hey, we're ready to go. I don't think you can prove this. I think the other guy did it. And we continued the case, and that particular client is out of custody, which is very unusual in a first-degree murder case. So as far as he's concerned, we could continue this till the cows come home, because if they don't try you, they can't convict you. So those are the type of case I've handled. Does anyone have any questions? No? And procedure, I'm sure you talk about motions to suppress, which sound wonderful, but they're very difficult to win. Usually when the police don't have a search warrant, then we'll file a motion to suppress. But obviously there's exceptions. There's the plain view exception. We have a couple of cases where a client wants me to file a motion to dismiss. A motion to suppress. However, through the window of the car there's the gun, and it's ex-felon in possession, so I'm not going to file that. I have problems with my clients sometimes because they want me to do things, but I have an obligation to the court. I can't file frivolous motions. So that's why I won't file things if I don't think it's appropriate. The other thing everybody wants is bail. Now, if you're in a first-degree murder case, you're probably not going to get bail. I have a couple where there's no bail. And if there is bail, usually it's so exorbitant, like $500,000, $1 million, and most people who get appointed counsel because they can't afford a retained lawyer are not going to be able to afford bail. Right. Now in federal court, what happens is you go to a detention hearing, and either you get out or you don't. You could sign what's called a personal recognizance bond, but you don't have to come up with any money. But it's difficult to get out. I have a couple of drug cases, and in drug cases there's a presumption that you're a flight risk and or a danger to the community. So you have to overcome the presumption because it's a rebuttable presumption. That said, I also do a lot of DUI cases. Now, there's a lot of people that don't understand DUI. You're pulled over for a DUI and the cop wants you to do field sobriety tests. They want to do the horizontal gaze nystagmus where they use their finger or they use a pen in front of your eyes to see if there's nystagmus, which is involuntary jerking of your eyes before 45 degrees. Now, this is a pretty subjective test because you can't see whether your eyes are jerking. The other thing is the walk and turn, which is 9 steps up, make a turn, 9 steps back on an imaginary line, or sometimes if it's in a parking lot, there'll be an actual line. This is also pretty difficult to do. And then there's the one-leg stand where you have to keep your foot up for 30 seconds. Now, I had a trial. It was actually in federal court. The reason it was in federal court because the offense happened at Lake Mead, which is a national park, which is federal. And the officer said my client failed the field sobriety test. So I had the officer do the field sobriety test in the courtroom, and he wouldn't have passed. I said, well, you would have failed, correct? And he's wearing his gun belt and everything. He goes, well, yeah, but I have an extra 15 pounds around the middle. I said, you could say the same thing about my client. It's like, thanks a lot, Mace. But the court believed me, and we ended up winning that case. So that was a good case. Now, sometimes when you have witnesses on the stand, believe it or not, they lie. And as a defense lawyer, I get to cross-examine them, and I have an opportunity, what's called impeach. So if they said something before which contradicts what they say at trial, I can bring that out. Now, I remember I had this case, and it's man-on-boy sexual assault. Sexual assault cases are very difficult to win. And this kid said, oh, my client had unconsensual sex with him several times. It was here, it was there, it was in the couch by the office. And my first question said, hey, didn't this happen in the couch by the bedroom? It's like, yes. Now, maybe you don't remember every time you had sex, but you're going to remember the first time, and you're certainly going to remember it if it's non-consensual. So after asking the complaining witness certain questions, well, did this happen? Did that happen? He said, well, maybe, possibly, evidently, more likely than not. And I asked the question in final argument. I said, ladies and gentlemen of the jury, you're supposed to find my client guilty beyond a reasonable doubt. Let me ask you a question. Your spouse goes away on a business trip for 3 days and comes back. You say, honey, were you faithful to me? And he or she says, probably, possibly. Maybe, more likely than not. Does that convince you? I read about it? I don't think so. And the jury acquitted in that case, and they should have. So I'm a trial lawyer. I like to go to trial. The good news is trial's fun. The bad news is preparing is a pain in the ass, but if you want to do well, you have to prepare. And I prepare and I prepare and I prepare. And when I write my final arguments, I'll probably redo it 15 times. But that's my method. That's the way I work. And once I do it, I will put a piece of paper with some bullet points, and then I'll do my argument, because I've learned I can't follow a script even if I write it myself. So that's what I do. And I think it's more natural. I don't think the jury's going to like it if you're standing there and you're looking at something before you say something. It's just not natural. It doesn't flow. You don't connect with the jury. Because as a lawyer, you have to connect with the jury. And when you do trials and do final argument, you got to start strong, you got to end strong. So if you have bad facts, you want to bury them in the middle. And if you're going to trial, you got bad facts. Because if you had decent facts, the case will resolve. Now, in murder cases, they always want first degree, but if you're going to plead to first degree murder, unless you get a cap, why not go to trial? But then again, on my gay love triangle, he's looking at life imprisonment, perhaps life without the possibility of parole, but we were able to resolve that case. I had another murder case, which was a bad case for the prosecution. It was a killing where the only evidence about my client was that he was seen leaving this apartment complex with a gun. They never found the gun. It was one shot. We ended up resolving that as voluntary manslaughter. Now, voluntary manslaughter is 4 to 10. So it could be, the lower number has to be 40% of the higher number. So it could be 1 to 2.5, 3 to 7.5, or 4 to 10. But it is probationable. And in this particular case, we stipulated to probation. And we had to stipulate to probation because my client's record was abysmal. And if we didn't stipulate, the judge probably would have maxed him. So that was a good result. I had another murder case. I've actually had some good results recently in which my client said, yeah, I shot my gun a couple of times, but I didn't shoot it in the victim. And we resolved it saying it was possession of a firearm and discharging a firearm by a felon, which is against the law, but 2 counts of discharging a firearm by a felon are a hell of a lot better than pleading to murder. So that's some of the stuff that I do. Does anyone have any questions? He was looking at potentially 20 years, but he didn't get that much. I think if I remember correctly, he got something, I think it was like, with it being aggregated, it was 4 to 10. So that was another good result. And he was a felon. He recognized he shouldn't have a gun, but he didn't kill the victim. I believe him. And actually the prosecutor, who's a tough prosecutor, believed him also, because we went and talked to him. He says, I'm not pleading to anything where I killed someone because I didn't do it. He was a man of principle, and he was right. So that's some of the stuff I do. I just wanted to give you a quick overview, and if no one has any questions, I'll just leave you to your own devices. Any questions? No? Sure. Well, here's the way I look at it. When they come to me, they're not guilty. They're only guilty if they plead guilty or if they're found guilty. So if you go to trial and the verdict is not guilty, they're not guilty, whether they committed the offense charged or not. And the ones that are most difficult are if I think they're actually not guilty, because then the pressure's on. I mean, the ones that I like, they say, hey, I did it, get me the best deal possible. Or, yeah, I did it, but I don't think they can prove it. I had this one case in federal court that was it was forged or using a forged or altered money order. And my client had 3 names. We were able to knock out 2. And what happened was he allegedly bought a money order for $100 and a money order for 50 cents. And somehow the 5 was put over the 1. And he tried to cash them. So certainly didn't look good, but my defense was it's forged and altered. Now, it might have been altered, but it certainly wasn't forged because it had his name. And the jury ended up acquitting, much to the chagrin of the judge and the prosecutor, but it just worked out well because there was a paralegal on the jury. Normally I won't leave a paralegal on the jury, but she worked for the sheriff's son, which I knew was a defense lawyer, so I figured maybe I'd have some help. And it turns out that the first vote was 10-2 for conviction. However, the paralegal was one of the votes for acquittal, and she said, well, wait a minute, the government hasn't met their burden, because the government has a burden of proof to prove every element beyond a reasonable doubt. And she said, let me tell you why they didn't. So they acquitted him. Client was very happy. I was kind of stunned, but I'll take it. And my big claim to fame is I won a case in front of the U.S. Supreme Court. I had a client who stabbed someone 32 times, broke off the knife in his head. Thought that JFK was his father, Marilyn Monroe was his mother, and he was hearing voices from Satan and Satan's assistant. Now, he was paranoid schizophrenic. There was no question that he did it. My only defense was insanity. And they were drugging my client, which they drugged him with 800 milligrams of Mellaril, which my expert said was enough Mellaril to tranquilize an elephant. And we filed a motion for termination of administration of medication, and that was denied with 1-page denial. Denied. That's it. No findings of facts, no conclusions of law. And I was so upset, I remember going back to my office saying, this case is going to the U.S. Supreme Court. Well, we lost at trial, there was a death sentence. Did the appeal in front of the Nevada Supreme Court, and it was a lively appeal, but I still lost. Now, if it's the highest court of the state, and there's a federal constitutional issue, you can file, it's called a writ of certiorari, which is essentially an appeal to the U.S. Supreme Court. The U.S. Supreme Court only accepts 1 in every 7,000 case, and they accepted my case. After they accepted it, obviously I was very excited. I got a call from this law firm. Oh, hello, this is Treat Adams III, and we'd like to assume the defense. Like, oh, so you want to help me? Oh, no, we'd like to assume the defense. It's like, so after I busted my butt and getting this case heard by the U.S. Supreme Court, you want to take it from me? I don't think so. But then there were some other firms that helped me, which was a good thing. And I did moot courts with the Pennsylvania Group for Protection and Advocacy. And this group was a bunch of mental patients and ex-mental patients that were into the right to refuse. So they said my client should have the right to refuse my medication. When then I did a moot court in front of Georgetown and a moot court with 4 very experienced lawyers from the NACDL, the National Association of Criminal Defense Lawyers. So then I went and I was arguing it. I was in this big case, the computer gang case, where we had 13 defendants it was going on, then I had to fly to Washington. I wanted to continue it, and everyone's like, no, Mace, you don't want to continue it. Things are doing too well for the defense. So I had one of the other defense lawyers also represent my client when I flew to Washington, D.C. And I remember when I stood up, my leg was shaking, but you couldn't see it. So I started, may it please the court, I said a couple of sentences, and then boom. As soon as they asked me a question, I was fine. And we went back and forth. And I remember I had a tete-a-tete with Judge Scalia. I said, I want him there in his natural demeanor. He goes, well, counsel, what if he came in and he painted his face yellow and he wore a clown hat? And I felt like saying, only if he borrowed one of yours, your bozo-ness. But I didn't want the headline to be Las Vegas lawyer held in contempt by U.S. Supreme Court. So I didn't say that. But we went back and forth. And at the end of the day, they ruled 7-2 in my favor. So I saved the life of David Riggins. The case is Riggins versus Nevada. You can take a look at it. Also, I've got the last 2 minutes of my argument. Well, I've got the whole argument. I've got the last 2 minutes of my argument. And if anyone's interested, you can email me and I'll send it to you. And it's mace@macelaw.com. And also, you folks can do me a big favor. I've been active on TikTok. I'm trying to do this. I do my 1-minute shorts, 1 minute with Mace, about various legal topics. And the handle is @YMace, WHYMACE. If you could follow me, I'd be most appreciative. Because the more followers, the better off it is. So it's the @YMace, WHYMACE. And my email is mace, M-A-C-E, @macelaw.com. I know Lisa has it and everyone has it, but I just thought I'd give it to you. But if you could do that, I would be most appreciative. I also wrote an article about my Supreme Court case. I think it's pretty funny, and most people do. So if you email me, I'll also send you a copy of the article. Sure. Yeah. No, I wouldn't be a prosecutor. I actually do some personal injury. I do dog bite cases. And in those cases, I represent the plaintiff. But in the criminal matters, I'm a defense lawyer. The DA's office or the U.S. Attorney's office prosecutes. And they're dedicated prosecutors. They don't have a private practice like I do. Oh, I've been a lawyer longer than you've been alive. I've been practicing since 1981. And I'm licensed in Nevada, California, and Massachusetts. I'm inactive, but I promised my mother, Crazy Charlotte, that I'd be a lawyer in Massachusetts. So I took the Mass Bar, even though I've never practiced there. And I actually fell asleep during the Mass Bar because I flew back and I had jet lag. And rather than sleep, I went to the beach to hang out with my friends. And after a half an hour, and the multi-state, the guy next to me is shaking me. He goes, man, you've been sleeping for a half an hour. You're never going to pass. Like, oh no. But I'm a speed reader. And I had taken the California bar before, so I still finished 20 minutes early. I went to this coffee shop and I said, I'm in the middle of a bar exam, I'm falling asleep, I want coffee, I need it now. Gave me a cup, I drained it. Gave me another cup, I drained it. Waitress came, put the pot in front of me, says, when you're finished, call me. I finished that pot, half another pot. I went back to the bar to take it, and I was so amped up on caffeine and adrenaline, I finished in half the time. Walked out, the guy next to me, he goes, I watched you sleep and you left early. I left 20 questions. He goes, if you do that again, I'm going to kill you. I said, I don't write nearly as fast as I read, but I passed. I'm 3 for 3 on bar exams, so I've retired undefeated. Just like the U.S. Supreme Court, I'm 1 for 1. I've retired undefeated, so no one's going to have a better win percentage than me. So that's my story, and I'm sticking to it. Any other questions? Well, it's been a pleasure speaking to you. I hope you enjoyed it. Have any questions? I'm happy to answer them. Ask Lisa. I'm always answering questions. And email me if you want a copy of my article in the last 2 minutes from the Supreme Court. I think it's very entertaining. So that's that. Well, nice talking to you. Thank you, Dennis, and have a good class, everyone. Bye-bye. You're welcome.